The insanity defense, trends and controversies. Insanity as a criminal defense. Today, almost everyone agrees that the purpose of criminal law is to serve and protect those of the public. Judges are primarily interested in the rehabilitation of a defendant. They do this through sentencing. This can be accomplished by probation, commitment to a reformatory or penal institution, or sometimes both. However, it is important to identify the different types of individuals penalized by the court system, as this often has an impact on their mental health. The insane criminal. The insane criminal is a person who has become insane after the commission of a crime for which the person has been found guilty or for whom insanity is not sufficiently integral to the offense to yield a verdict of not guilty by reason of insanity. The criminally insane have been judged by the court system to be not guilty of a criminal act due to their mental state or supposed mental illness. Given their mental state, all healthcare services rendered should be taken into account. A number of states have built mental health facilities specifically for insane individuals. Previously, they were referred to as asylums. The terms insane, mentally defective, or otherwise specified are seen as derogatory and perhaps offensive today. Individuals or psychologists would no longer refer to someone with a mental disorder as mentally defective or insane. I use these terms loosely, and they are derived from current legal codes, laws, statutes, and definitions. The insane criminal continued. Good or bad law, what's considered right from wrong? Some scientists believe the range of freedom of choice differs for each criminal, especially those considered insane. Conversely, there is much controversy surrounding the term insanity in both social and legal contexts. It's difficult for doctors, psychiatrists, lawyers to understand each other when discussing insanity. But what exactly does insanity mean, and how can the court system at best treat or rehabilitate individuals who fall outside the normal constraints of society? What is insanity? Insanity is rather a social and legal term than a medical one. It implies mental disorders resulting in inability to manage one's affairs and perform one's social duties. For legal purposes, as sometimes essentially defined, such as soundness of mental condition, as with regard to any matter under action, modifies or does away with individual legal responsibility or capacity. Within the diagram, I have the different types of mental or insane individuals. The term has been variously defined by statutes and variously interpreted by the courts. It covers a variety of disorders, the principal forms being maniac depressive, as you can see in the upper right-hand corner, alcoholic insanities, dementia, and general paralysis. Mental deficiency, temporary delirious conditions, and trance are sometimes but not usually included. Psychoneurosis and psychopathic states are distinguished from insanity, but with no sharp line of demarcation. The test of insanity for the determination of legal responsibility or capacity, criminal or civil, differs from that by which insanity is determined for medical purposes, with the result that various conditions which are medically recognized as insane are not considered as doing away with legal responsibility or capacity. McNaughton's right-wrong test. In order to remedy the court system and best treat insane individuals, the court system devised the McNaughton right-wrong test. This rule has various other formulations such as the irresistible rule, the New Hampshire rule, the Durham rule, and today the American Law Institute's model penal code rule. Briefly, and to give some background, the rule originated from, to no surprise, Daniel McNaughton. McNaughton was under the paranoid delusion that the Prime Minister of England, Sir Robert Peel, was trying to kill him. When he tried to shoot Sir Peel from behind, he mistakenly shot and killed Sir Peel's secretary, Edward Drummond. The aftermath of this incident created public outcry and revealed much of the criticisms of the McNaughton rule today. There is much controversy surrounding this rule, and while it may be easy to attack, my goal is to analyze the insanity defense in Maryland and outline the fundamental rationale of the irresistible impulse test it employs. This is a diagram showing the evolution of the McNaughton rule over time, starting in 1843 and ending with 1964 and the Insanity Defense Reform Act of 1984. The McNaughton rule provides as follows. Every man is to be presumed to be sane, and that to establish a defense on the ground of insanity, it must be clearly proved that at the time of the committing of the act, The party accused was laboring under such a defect of reason from disease of mind and not to know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. Cognitive ability versus locus of control. The test to determine if a defendant knows right from wrong is based on the idea that the defendant knows the difference in order to be convicted of the crime. Now, this may seem easy enough to understand, but it is much more misleading on its front, and so many dilemmas arise. One being whether a defendant knew his or her criminal acts were wrong, or that laws exist to prohibit these acts. Thus, criticism of the Manhattan Rule or insanity defense focuses on one's cognitive ability and awareness rather than their ability to control their conduct. Questions also arise about how to best treat these individuals. The Manhattan Rule in Maryland. In Maryland, the test to determine whether a defendant is not criminally responsible for certain conduct is twofold. That being to appreciate the criminality of the conduct or confirm that conduct to the requirements of the law. The burden is on the defendant to establish to the defense of not criminally responsible by preponderance of the evidence. In other words, the defendant must be suffering from a mental defect at the time he or she committed a criminal act, know the nature and quality of the criminal act, or that it was wrong. As you can see, the test is twofold. It equates mental disease or defect of mind, plus the inability to know nature or quality of the criminal act, which determines a not guilty verdict inside of the Manhattan insanity defense. There are different sections based on mental capacity. The insanity defense, if used appropriately and determined by the court as legally justified, can lead to an acquittal. Whereas a defendant found guilty but not insane, knowing right from wrong, is eligible for mental health treatment. And an individual's diminished capacity or competence can only delay the hearing or reduce the severity of the offense, rather than when designated as insane or mentally ill, a judgment of acquittal could be rendered. State versus Spencer. Maryland stands with most jurisdictions having adopted the right and wrong test in State versus Spencer, 1888. In this case, the defendant was convicted of murder. They found that the defendant was actuated by a motive of breaking nature, having thus premeditated the killing. The trial court refused to admit evidence of the defendant's mental state and said, in quotes, if at the time of the commission of the alleged offense, he, the defendant, had capacity and reason sufficient to enable him to distinguish between right and wrong and understand the nature and consequences of his act as applied to himself. He is a responsible agent and amenable to the criminal law of the land for the consequences of his act. And as you can see on the right, there's a diagram showing you the not guilty verdict, which is the mental deficiency and the inability to know the nature or criminal or quality of the criminal act. State versus Spencer continued. The court specifically rejected the irresistible impulse test in this case and held it had no place in Maryland. In their eyes, the law is not a medical nor a metaphysical science, and to think otherwise would be an objection to the law. Instead, the law should require no peculiar emotion of mind for whether he or she was solely capable of having criminal intent. Unless testimony proved that the defendant was insane, his appeal will remain mute and the expanded test would cease in this jurisdiction. Roby versus State and Never versus States. Which will you choose? However, it's not a choice, sanity or insanity. The more recent Roby versus State and Never versus State directly affirm the sole criterion in Spencer. That is, if there's any evidence of a cover-up, it is clear the defendant knows the difference between right and wrong. Taking a look at Roby versus State, the trial court found that the defendant was insane each time she beat her infant daughter, but was sane thereafter. Thus, in Maryland, only insanity at the time of the crime can excuse the defendant. Thomas versus State, 1955. The Thomas case, however, further reveals Maryland's position and deals with the burden of proof needed to prove insanity. According to the Maryland Law Review, the defendant was indicted for first-degree murder, rape, robbery, and burglary by the grand jury of Baltimore City. The trial court directed the jury to apply the right and wrong test adopted in Spencer and stated the burden is upon the defense to prove. As we may know and further emphasized in Roby versus State, once the defendant has provided sufficient evidence of a mental disorder, the burden then shifts to the state to prove insanity beyond a reasonable doubt. Thomas versus State continued. The basis of the defendant's plea was poor. His evidence relied heavily on witness testimony. They attested to the fact that he had been drinking prior to committing these acts charged. This was by no means sufficient enough to satisfy the proof required of someone mentally defective. In fact, the testimony of the chief medical officer reads as follows: poor intellectual endowments, but not clearly mentally defective, cannot read or write. Certainly would conclude from these examinations that the patient is not so defective that he would not realize that it was wrong and illegal to rob, rape, and murder. I felt that the patient had sufficient intellectual capacity to know that it was morally and legally wrong to rape, murder, rob, or any of the acts of which he is accused. To his dismay, the psychiatric testimony did more to support the position of insanity than what his defense was. Conclusion. Maryland primarily considers intelligence within the insanity defense. Yet, as seen within the cases listed, many find the defense excuse ignorant and ponder over what it means to be morally or legally wrong. In the beginning of this PowerPoint, I noted the two elements of the insanity defense, that being the defendant must suffer from a mental defect at the time he or she commits the criminal act, and the second being the trier of fact must find the defendant knew their acts were wrong. But what meaning of wrong does Maryland adopt? Should we punish and condemn those who break the law or in general act out against society? The question will remain. The Spencer case, of which Maryland espoused in its youth, makes it clear that the intellectual functioning of the mind is separate and distinct from emotional impact or control, and that law should deal solely with intent and criminal liability to commit a crime. On the other hand, jurisdictions like in the Thomas case that place the burden of proof on the defense feel such a rule would encourage abuse of the insanity defense. Still, in Maryland, if the defendant knows the difference between right and wrong, yet is otherwise mentally disordered, he or she is not considered insane under the Maryland test. The primary role of McNaughton's rule is to deter and punish crime. However, society continues to view insanity as a social claim rather than a legal one. And it's clear research exists on the freedom of choice and mental capacity of insane criminals compared to normal ones. Questions to ponder. Do you think the insanity defense should hold weight in the legal and rehabilitation system? Here are the list of sources that I used throughout the various slides and my quotes. Have a good one.